Welcome, legal enthusiasts and followers of South Africa's high-profile cases. Today's episode dives deep into a watershed moment in South African criminal law Judge Ratha Mokgoatlheng's recent ruling on Section 174 of the Criminal Procedure Act, CPA, during the Senzo Meyiwa murder trial. Our specific focus will be on the controversial hearsay testimony of Constable Sizwe Zungu and on the broader implications and potential loopholes this precedent could create. We'll examine the specifics of Judge Mokgoatlheng's controversial judgment and the reactions it's elicited in the legal community. By the end, you'll understand why many believe this ruling could have a long-lasting impact on judicial integrity and criminal litigation in South Africa. Now let us do some legal analysis on Mokgoatlheng's Section 174 ruling in the Senzo Meyiwa trial. The murder trial of celebrated footballer Senzo Meyiwa has gripped South Africa since 2014. 5 men are charged in connection with his fatal shooting. In August and September 2025, once the state closed its case after years of evidence, defense counsel for one accused, Mthokosiseni Mafisa, applied for a Section 174 discharge, arguing the state's case was so weak there was no evidence to answer. Central to the discharge application was the testimony of Constable Sizwe Zungu, the only witness placing all 5 accused together at the relevant place and time. Zungu, a police officer from KwaZulu-Natal, stated he socialized with the accused at a hostel in Vosloorus the very night Meyiwa was killed. He described a bizarre celebration after the crime and detailed seeing some accused in possession of firearms. However, serious issues undermined this testimony. Zungu's testimony was full of internal contradictions. Defense pointed out that his affidavit and in-court statements differed in material respects, particularly around the accused's whereabouts and means of transportation, casting doubt on the entire narrative. Most importantly, the original contemporaneous statements and notes on which Zungu based parts of his testimony had been destroyed or were missing, and much of the crucial information was never formally admitted into evidence. The defense characterized Zungu's evidence as unreliable and, at best, triple hearsay, a chain of rumors passed via several individuals, some of whom never testified. Judge Mokgoatlheng acknowledged these evidentiary issues, but ultimately found, in relation to Mafisa and others, that Zungu's testimony and supporting evidence like cell phone records created a prima facie case that called for a defense. However, the ruling has been roundly criticized for the blurred lines it drew regarding what constitutes evidence under Section 174, especially when much of it was disputed hearsay or off-record. Zungu's testimony and related statements failed most criteria for hearsay admissibility. They were not directly observed, not subject to cross-examination, and at critical points rested on informal conversations never properly recorded or verified. Much was not on the official record. Despite this, Mokgoatlheng allowed the state to build its prima facie case heavily around Zungu's narrative amplified, but not directly corroborated by digital evidence and confessions alleged in court. Legal critics argue that the judge came dangerously close to relying on inadmissible or even phantom evidence testimony alluded to, but never placed on record in compliance with the statutory rules of admissibility. Section 174, Standard and Controversy. The prima facie test. South African courts have consistently emphasized a low bar. If any prima facie evidence exists that might reasonably support a conviction, the accused must be put on his defense. Even weak or disputed evidence passes muster unless its poor quality makes it impossible for a reasonable person to believe. But courts are instructed not to weigh credibility or resolve factual disputes at the discharge stage. Those are for full trial, not the crisp Section 174 inquiry. The danger, as seen in high-profile cases like S.V. Dewani, S. versus Agliotti, and now, arguably, the Meyiwa trial, is that credibility assessments creep in unconsciously and judges become triers of fact prematurely. Comparative jurisdictional approaches. Other common law systems like the UK and US enforce stricter demands for corroboration and admissibility at the no case to answer, Rule 29 stage. There, judges can only acquit if, upon reviewing recorded and admissible evidence, there is genuinely nothing on which a reasonable jury or judge could convict. Hearsay can support a conviction only if it passes rigorous tests, and the defense can challenge it through testing the evidence or the statement's maker. South African law, by contrast, allows for greater discretion and, as this case demonstrates, can edge towards the precarious use of evidence not officially on record when judges are insufficiently disciplined in applying the procedural standard. This subjective flexibility, imported from a unique blend of English, Roman Dutch, and domestic law, is both a strength and a source of legendary legal controversy. Now let us look at legal implications and potential loopholes. Risks exposed by Mokgoatlheng's ruling. Setting a precedent for looser evidence standards. By allowing the case against certain accused to proceed despite reliance on Zungu's contested, quasi-hearsay testimony, with much of it not formally on record. Mokgoatlheng's ruling inadvertently signals to the legal community that the threshold for sufficiency at Section 174 can be lowered when procedural difficulties exist, e.g., missing notes, uncorroborated witness accounts. Defense lawyers may exploit this precedent, arguing that if the prosecution uses thin or informal evidence, they too can demand acquittals at a very early stage, even before the state's actual case is concluded, undermining both prosecution and due process needs. If judges increasingly accept informal, verbal, or unrecorded declarations as evidence, Section 174 may become a tool to preempt full scrutiny of contested facts, rather than a shield protecting the innocent from prosecutorial overreach. Courts are cornerstone institutions in South Africa's democracy. Judicial integrity requires that decisions be made transparently and on the record, with clear reasoning accessible for public review and potential appellate scrutiny. Decisions counting on evidence, not formally led statements, rumors, or notes, never entered as exhibits, undermine the principle of open justice. In the Meyiwa case, public confidence is further threatened by lost or destroyed notes, raising suspicions about the veracity and integrity of the testimony. Judicial remarks or observations made off the cuff, blurring the boundary between personal impressions and legal facts. Outcry among legal professionals and the public not only about procedural questions, but also about the propriety and decorum with which justice is conducted. See debate over Judge Mokgoatlheng's recent racialized outbursts and the aftermath of his subsequent public apology. How might this affect future proceedings? Erosion of evidentiary standards and judicial confidence. Should this interpretation stand or become widespread, accused persons may increasingly be acquitted or put on their defense based on evidence never formally tested or recorded, breaking down the traditional wall between court record and decision-making. This not only affects trial fairness but also confidence in the appeal and review process, since appellate courts rely on the completeness and clarity of trial records. This also sets a prosecutorial dilemma where state prosecutors may find themselves burdened by the need to tie up every procedural loose end to avoid gamesmanship. Conversely, they might be tempted to pad their cases with supplementary, if not always strictly admissible declarations, expecting judges to overlook evidentiary defects on pragmatic grounds. The legal profession has combined concern and criticism in response to Mokgoatlheng's ruling. South African Criminal Procedure Forum warns that Section 174, designed to protect the innocent, is at risk of being misused to game the system, threatening judicial integrity when decisions are made on untested or off-record evidence. Constitutional lawyers argue for reframing judicial conduct in line with constitutional ideals of transparency, equality, and the right to a fair trial, urging caution against importing old practices unsuited to post-apartheid demands for just and open process. Public and professional outrage has also been amplified after Judge Mokgoatlheng's public racialized comments, with senior legal bodies and bar associations calling for disciplinary and ethical reviews, insisting that judicial impartiality and integrity must be visible as well as actual. In conclusion, Judge Ratha Mokgoatlheng's ruling on Section 174 during the Senzo Meyiwa trial, especially with regard to Constable Zungu's hearsay evidence, has ignited an urgent dialogue about the integrity and direction of South Africa's criminal procedure. While Section 174 exists to protect the core right to a fair trial and the presumption of innocence, its misapplication, or the relaxation of admissibility standards, risks transforming it into a shield for both incompetence and potential injustice. Hearsay evidence, including Zungu's deeply contested testimony, must remain subject to the highest standards for admissibility. Testimony that cannot be cross-examined or is not on record cannot legally or practically serve as the basis for a conviction or discharge. Judicial integrity and transparency demand unequivocal record-keeping, well-reasoned rulings, and consistent, fair application of the law. Only reforms that clarify, tighten, and enforce these standards will safeguard both the trust of the public and the constitutional promises at the heart of South African justice. Whether the Meyiwa trial goes down in history as a turning point for procedural reform or a cautionary tale of lost evidence and lost faith, will depend on what the judiciary and legislature do next. Constable Zungu's testimony was pivotal, despite questions about reliability. How should courts weigh human memory against forensic evidence? Is it fair to build a case on circumstantial evidence like party attendance, photos, and hearsay, especially when lives are at stake? If you found this analysis helpful, subscribe for more in-depth commentary on legal developments, judicial reforms, and the big cases shaping justice in South Africa. Comment below. Do you believe Judge Mokgoatlheng's ruling achieved justice, or did it risk the very integrity it sought to uphold? Thanks for watching, and please don't skip the ads. I'll catch you on my next upload, Skybridge checking out. Bye.